On behalf of Baker McKenzie and the IMT Group, welcome and thank you for joining today's webinar, Asia Pacific IMT Webinar Series, Latest Customs Audit and Enforcement Trends in Europe and the United Kingdom. My name is Yaiko Hodaka, and I'm the co-chair of the Asia Pacific Industrial Manufacturing and Transportation Industry Group of Baker McKenzie, based in Tokyo. As many of you may notice, in this series of webinars, we have learned about the customs audit regime and practice in Asian countries. After completing the webinars focusing on 6 countries, including Thailand, Indonesia, Philippines, Vietnam, Malaysia, and China, we have expanded the scope outside the region and discussed about US practices in the previous session. And in today's session, we will focus on Europe. Due to the distance from Asia, we are not quite familiar with customs audit practice in Europe. But for example, we often heard that the European customs authorities are more active in terms of verification of certificate of origin when compared with the Asian countries. And we are curious how they identify a target and how the process goes once the audit is commenced. Or we are also interested to know the recent developments of forced labor related regulations and enforcement situation in Europe. Or after Brexit, how UK practice differs from other EU member states. We have a lot of questions, and I'm happy to introduce our esteemed colleagues from UK and Brussels who can answer those questions today. I'm pleased to be joined by Lionel Van Riet, partner from our Brussels office, and Jennifer Revis, partner from our London office. Jennifer is a partner and head of Baker McKenzie's Customs and Excellence practice in London and co-head of Baker McKenzie EMEA Customs Group. Jennifer focuses her practice on the public regulation of international trade, particularly in the wide range of compliance issues such as customs, excise, anti-bribery and corruption, WTO, anti-tax evasion, and Brexit matters. Lionel Van Riet has joined Baker McKenzie as customs lead in February 2022. Lionel has more than 20 years of experience in the field of customs, international trade, excise, and energy levy. Lionel focuses mainly on customs transformation initiatives, customs essentials, customs processes optimization, and customs compliance. He has extensive knowledge and experience in the field of export control and sanctions in assisting companies to review and manage their export control compliance monitoring system. And now I will hand over to Leo and Jenny to kick us off with today's presentation.
Thank you very much, Yoko, and lovely to meet you all. And good morning or good afternoon, depending on where you're based. So for today's session, we'd like to start with why customs compliance matters. Then we'll look at the types of UK and EU customs audits, the focus areas in an audit, how to mitigate customs risks and prepare for an audit, and then looking towards the future, which is always important, how you can make sure that in the future you're best prepared for any audit situations and you best maximize your customs compliance. And many of the topics which we'll touch upon today are topics which you will have come across in similar sessions covering other jurisdictions in the world. So there are definitely synergies when it comes to customs globally, but we'll also touch upon the specificities for the UK and the EU. So moving on firstly to why customs compliance matters. And you'll see on the next slide a number of different estimates or views as to how some of these issues pop up. And really, when we're talking about customs, we're talking about the cross-border movements of products, so export from one jurisdiction and import into another. And what we find is that the largest multinational companies in the world serve, so 20% of those serve more than 150 countries. So many companies are dealing with the imports and export laws of multiple jurisdictions when they're handling customs matters. And it may not come as a surprise to you, but 90% of companies surveyed do not feel in control of their global customs operations. And that's often because when it comes to customs, it's an area that has received less investment within companies than, say, direct tax. But as we'll see, particularly now as we're approaching an economic downturn, customs authorities will be looking to maximize their revenue, and therefore customs audits, certainly it's the case in the EU and the UK, are on the rise. When we talk about customs, 80% of identical topics come to mind when we're talking about this, and we'll see that as a theme coming through this presentation. And interestingly, 75% of companies feel that a harmonized approach when it comes to customs would bring about significant savings. And whilst many multinational companies have local decision makers that deal with customs issues, many of these issues are actually global and would benefit from some global direction at the top. So Leo, moving on to the next slide for a few thoughts from your perspective on this.
Yeah, thank you. Thank you, Jenny, for that. I think that actually it gives a good feeling on why compliance matters, certainly. And then if we look at the next slide, we just have focused on a few elements, because on a surveyed company, you see that 75% of the companies are saying that yes, more harmonization would bring significant savings. Well, in the world of customs, of course, legislation can be quite similar, but quite some difference still remain. One way to harmonize and to get more in control, more on top of the trade compliance, more on top of the regulatory watch, more on top of the savings, is to think about how can I start to align my data. Because the key concept, and we will come back to that later, like classification, origin, valuation, those elements, they are nowadays, they are supported, not even created by some, in a certain way, by data. And mastering those data enables you not only to be compliant, but actually to go after savings, not in one country, but in multiple countries. So on that slide here, what you see is those three concepts: trade classification, customs value, trade preference, where we have noted in practice, really down to earth, practical side, what is there to be mentioned. On the material master data, the different SKU units, you export one product, it can be a set, it can be a kit, but if you do some returning goods management, some maintenance, you might end up having one SKU with several different commodity codes. You need to master that. If you don't, two things will happen. Savings will be lost. You will start paying more duties than what you owe. And secondly, you will put up a wrong customs declaration, which means, and which is it's a tax breach and could lead to very annoying consequence. So that's a slide just to put in picture a bit what Jenny has said, just to bring that down to your everyday life with how things are being run within a corporation. So if we slightly progress maybe to the next part of the presentation with the next couple of slides, I will give you back the word, Jenny, before I jump in with EPPO and Olaf. But before that, maybe if you could just give us some insights on the EU and UK customs audit trends.
Thank you, Leo.
On the slides.
Yeah, moving on to EU UK customs audits. So we talked about, as part of this presentation, that there are different, we're seeing definitely an increase in trend in enforcement, and EU UK customs audits is certainly one area where this is arising. So if we can move on to the slide called EU UK customs audits. So what types of audits are we seeing at the moment? So there are definitely different types, and that's one of the first things you should identify when you have been notified that you're going to be subject to an audit. What type of audit is this, and what will the customs authorities be focusing on? Now, it could be an audit because you've applied for the Authorized Economic Operator Status, AEO, and that obviously will go through its own very specific process because you will have been through an application process and completed explanations of what your customs compliance processes are, etc. Other types of audits that you may encounter are just a standard routine audit that may arise at any point, although these tend to arise on a periodic basis. So if you haven't been audited for, say, 3 to 5 years, you're much more likely to be subject to an audit in the near future. And these can be carried out in one of two ways. It could be a desktop audit, where you are notified in writing and you share information in writing with the customs officer that then looks at this in their office and comes back to you with any follow-up questions, or it could be an in-person visit. And then finally, you may have specific audits on a particular topic or recurring audit if you've had one in the past and issues have arisen. And these types of specific audits will generally focus on one particular area. So it could be on how you've certified that goods meet the requirements for trade with a particular free trade agreement. And that generally, if that happens, say the EU-Japan free trade agreement, it will generally be because if you've exported products to Japan under preference and the Japanese authorities have some concerns as to whether those products did indeed qualify for preference, then they would contact the EU customs authorities or the UK customs authorities and ask them to assist them in a verification process, which would then trigger that audit. Could also be an audit linked to an application you've made for a specific customs procedure, such as inward processing relief or customs warehousing. Now, what do we see as the priority issues when these audits happen? And these won't come as a surprise. They are the typical pillars of customs compliance as we see, such as customs valuation, tariff classification, origin, particularly where you're claiming preference. And then I mentioned sort of special procedures as well as if you're operating one of those. Now we've circled here, or put a square box if you prefer, around related party valuation. So those are scenarios where you are trading goods between related companies, so companies within a group. And why is this a priority issue? It's because customs there's not a complete alignment between the principles for customs valuation and transfer pricing. And companies in related party situations will generally want to value their products based on the pricing that's been established for transfer pricing purposes. And that may be challenged by the customs authorities if they consider that the relationship between the parties has influenced the price and it's not a properly arm's length transaction. The other challenges that we see in related party transactions is where there are retrospective transfer pricing adjustments that have impacted that price, or where there are other arrangements within the group, such as arrangements relating to IP in the form of an assist or a royalty that may also need to be taken into account. So this is a real area of focus, both in the EU and the UK, and an area where we've seen some developments in terms of the case law and also the guidance, and we'll come back to that later on in this presentation. So what companies do the authorities want to audit? High risk or moderate risk companies will be the priority. So customs will do a risk profile of the companies based on where the companies operate, where, depending on whether they are AEO certified. So an AEO certified company will have a lower risk rating, and also depending on the types of products that they trade, some products being viewed as higher risk than others. Customs will also want to be targeting specific issues. Again, much of that can be picked up through Customs' data analytics, which enables them to identify companies that have higher risk transactions but also as a result of any customs applications you've made, such as for a customs procedure or AEO, or if you've made prior disclosures. Customs will often want to come back and check that those same errors have not reoccurred. And finally, there can be referrals, and this is something that I'm now going to hand over. If we can move on to the next slide, please, to Leo, which will touch upon one of the most important developments in terms of these referrals.
Yeah, thanks, Jenny. And indeed, I think I like the previous slide because it set the scene quite clearly. Now we prepare you for what's coming here on this slide, because maybe you've heard and you are familiar with the two acronyms EPPO, European Public Prosecutor Office, or the OLAF. But if you are not acquainted with them, you will soon be, because I can guarantee you that in the EU, and before I hand over to Jenny, in the UK as well, those two acronyms are quite very known. The EPPO, I mean, is existing for a bit more than 2 years. It's an independent, decentralized prosecution office. It's present in 22 countries out of the 27. So you have 22 participating EU countries. So every member state is putting forward a prosecutor. So you have a Belgian prosecutor and so on and so forth. It's quite important because it's an independent and decentralized prosecution office. It has quite extended power. It can investigate, prosecute, and also bring to judgment crimes against the EU budget. So that's very important. So technically, they are. If you are used to discuss with the national tax authorities, with your customs authorities, you have the litigation office. Then from time to time also there is a lawsuit coming out of those discussions. Okay, that's fine. But the EPPO has less the willingness to find a transaction with the companies. They are not there for that. They are there to investigate, to prosecute, and also bring to judgment people that commit fraud or infringements or breaches against the EU budget. So that's very important. We see a lot of cases. Just to give you an idea on the VAT, the threshold to be brought to the EPPO is 10 million euros. So as from 10 million euro, you can be brought before the EPPO. For customs, and this is a customs webinar on customs, that threshold sit tightly on your share, is not 10 million euro, it's 10,000 euro. Only 10,000 euro, and then possibly you can be brought before the EPPO. So technically, it's quite annoying for a lot of companies. So what is there the difference between the EPPO and the OLAF? Well, the OLAF is quite another type of animal. The OLAF is founded at the end of the 90s, in 99. They wanted to detect, to prevent economic crime from happening, also economic crime involving the EU funds and budget. They don't have prosecution power, but they have the power to start auditing and conduct spot check to a company or an operator activity. So that's quite important. The two together are forming a dangerous mix, if I may put it like that. So that's quite important to keep that in mind. To give now an example, and before I pass on to Jenny. Quite recently, the OLAF has, during COVID period, the OLAF has initiated a round of audits on e-commerce involved companies. It means brokers, it means companies importing the goods, also platforms, looking at are your goods not undervalued? So technically, are you just declaring the right amount on your invoice and then for your taxable basis? And I can assure you that in Belgium, this has led to massive number of files that were referred to the EPPO. We talk about the OLAF is asking more than 300 million euro only for Belgium in terms of additional duties to be handed over to the EU budget, arguing that the goods have been massively undervalued by a lot of companies in the EU. And here it was in Belgium. To give you an idea, in the Netherlands, we talk about 1 billion, and it's only two of the countries. So technically, it's watch out for that one. That's quite important. And that's not only EU. This also has somehow maybe the starting point, or it's certainly a very well-known case in the UK. But for that, maybe Jenny, if you could take us through the UK situation.
Yeah, so for the UK, following Brexit, the UK is obviously no longer subject to the jurisdiction of EU institutions. So OLAF no longer has a role to play in investigating customs fraud in the UK. And the establishment of the European Public Prosecutor's Office also doesn't have a role to play in the UK. But there are still some spillovers from the Brexit time. And as Leo alluded to, there's been a long-running dispute that started well before the discussions around Brexit, linked to the UK, according to the EU, failing to properly prevent and then investigating customs fraud linked to undervaluation of products that were being brought into the UK. And why is this a problem, or why was this a problem? When a country is a member state of the European Union and they collect customs duties at the border, they collect it on behalf of the European Union, and it makes up the European Union budget. And very little of those customs duties that are collected are actually held by the member state themselves for their own budget. They keep about 5% to cover their costs for running the customs border operations, but the rest is all remitted to the European Commission for their budget. So the European Commission plays this overseeing role in making sure that the member states police their borders. And so there was this dispute with the EU, which resulted in a court case brought by the European Commission against the UK for under collection of customs duties between 2011 and 2018. And the European courts largely found in favour of the European Commission, and the amount claimed by the EU was 2.7 billion in euros of uncollected customs duties. And so far, hundreds of thousands of euros, 100 millions, I should say, of additional compensation has been paid by the UK to the EU, and we're expecting further payments to continue. So that's to sort of set the scene for the UK in the post-Brexit world of realising that there are potentially areas where the borders need to be better policed. And as Leo said for the EU, it's very similar for the UK. There is definitely a focus on undervaluation when it comes to e-commerce and valuation as a whole in terms of a compliance area. You'll see on the slide that I noted there HM Revenue and Customs, so that's UK Customs annual report and accounts for 2021 to 2022. They were published recently, and they set out the priorities for the customs authorities, customs and tax authorities, because in the UK they're combined, in terms of what they are looking to achieve over the next year. And you'll see in there, they mention specifically this litigation with the EU and the additional amounts they're having to pay to the EU. But they also mention that as a result of Brexit, there's been a huge increase in customs declarations for movements between the EU and the UK and vice versa. But the result of that, particularly for the movements coming into the UK, is that has meant a big increase in customs revenue as well. So the amount of customs duties has shot up. Now the UK is collecting duties for its own account and its own budget, and no longer that of the EU. It's certainly more interested in making sure that the right amount of customs duties are collected. So on that note, if we move on to the next section, we've talked about the types of customs audits, the increase in enforcement and the reasons why. What areas do the customs authorities focus on in an audit? And you'll see on the next slide that these are very similar to what you will have encountered elsewhere in the globe. And we're looking at the key pillars of customs compliance. And these effectively make up how much customs duty a company pays at the border. So the first element will be how you've classified your product. So what is your product? And what tariff classification code have you assigned to that import? So an import into the EU, an import into the UK, you need a 10-digit code, and that code will determine the duty rate that's applicable to your product. And as we know, for a number of areas, such as multifunction devices or more recent high-tech products, chemicals, car parts, etc., this can be quite a tricky area, and one that can result in disputes with customs, who generally you'll be looking for a code that has a higher rate of duty than the one that you selected. The second pillar is origin, and particularly origin as results to preferential claims. So where you are seeking to get the benefits from a free trade agreement, or you're importing from one of the developing countries under the generalized system of preference. And those regimes will allow you to import products either at a nil rate of duty or a reduced rate of duty, but this comes at a price. You need to prove, if you are audited, that the products did definitely qualify as originating from that country under the rules of origin that are set out in that arrangement. And so that can lead to a certain amount of discussions with customs, providing evidence, etc., which may require you to go back to your supplier for that evidence. Now, the duty rate that you've determined based on the tariff classification then has to be applied to a value. That value can be straightforward if you have a transaction between unrelated parties. It's generally the price paid or payable for the product. Also, what we refer to as the application of method 1, or the transaction value method, which applies to 90% or so of transactions. But there can be challenging areas, as we mentioned previously, particularly where you are relying on transfer pricing in the scenarios of related party transactions, or scenarios where you may also have to account for additions to the price paid or payable, such as royalties, license fees, assists, etc. And for that reason, this is an area that's really focused on by the customs authorities, particularly in the related party transactions. Now, you may have seen in the past few weeks, there's been quite a few developments in this area in the EU, and it's definitely one to continue watching out for. We've had the Hamamatsu case, which you may be familiar with, which was about 3-4 years ago, a European Court of Justice case that looked at a scenario where a company had claimed a refund of customs duties based on a downward retrospective transfer pricing adjustment, and the German authorities had refused to offer that refund. Now, the judgment that came out of that European Court of Justice case was very unclear, and as a result, many of the customs authorities in the EU and the UK as well had just continued to apply their previous policies when it came to how to deal with these types of cases, which for most countries meant that if you had an upward adjustment, you had to report it and you had to pay extra customs duties. But by and large, the customs authorities would still allow you to base your customs value on transfer pricing methodologies. Now, about a month ago, there was a publication of the highest court in Germany, the Supreme Court, of the Hamamatsu case, where the German court decided that transfer pricing adjustments can be ignored, either upwards or downwards, and you can still use method 1, the transfer pricing method, based on the transfer pricing arrangement. Now, that's quite a controversial judgment. We don't necessarily expect that other member states will follow this, but it's certainly setting a trend for there to be further discussions at the EU level on how to deal with these types of scenarios. Shortly after the publication of this judgment, it's unclear whether it's related or not, the UK customs have also published revised guidance on customs valuation. And one of the revisions that came as part of this publication was the fact that UK customs says that in most scenarios where a margin-based transfer pricing methodology is used, it likely won't be acceptable for customs valuation purposes. Not much more is said. It's a bit of a bombshell in the customs valuation world, as this has never been the policy of UK customs so far. So we are in discussions with them to try and clarify exactly what they mean by this. And if that is indeed their new policy, how they propose to deal with the many arrangements that companies have at the moment with UK customs in such scenarios. So this is definitely an area to keep out watching for, and that will continue to be one that's high on the agenda of authorities in audits. And finally, you've calculated what your duty liability might be. Now, there are different options, depending on the facts, to claim duty relief if preference is not available. And that could be, for example, if you're processing in EU, you might apply for inward processing relief, processing outside the EU or UK, outward processing relief, or if you're just using the EU or the UK as a distribution hub, you might think about customs warehousing. So a number of different areas to mitigate your duty liability, but obviously that comes at a cost from a compliance perspective, and will mean that the EU or UK customs authorities will want to make sure that you're complying with those rules, and therefore that will be the subject of audits as well. So moving on and looking now at how to mitigate those customs risks and how to prepare for a customs audit. So starting with an audit overview. So generally when an audit's going to happen, you will receive an audit announcement from the customs authorities. They will tell you what they're expecting to come and audit. And we talked previously about the different types of audits. So you should know at that point whether it's a standard audit, looking at general customs matters. And in those scenarios, customs authorities will generally pick a sample of customs entries across your operations they wish to audit, and will look at all the different customs pillars that I mentioned previously. But it could be an audit for AEO, or it could be an audit focused on one specific issue, like the operation of a customs procedure. Now, customs officers have very broad powers when it comes to auditing. They can request pretty much any document they want. They can inspect premises, they can take documents away. So the powers are far-reaching. Generally, when you're audited, the EU-UK statute of limitations, unless it's a scenario where there's been gross negligence or fraud has been committed, generally the statute of limitations, and that's based on the EU legislation, the Union Customs Code, is 3 years. But in a number of European countries, that can be extended based on the local rules. So worth checking depending on which member state you're being audited in. Now, as a result of the customs audit, if you have been found to have committed violations, then there is a risk of penalties. And the penalties are set at the member state level. So it's not based on the harmonized European legislation. The harmonized European legislation sets out the framework for how the customs rules are set out, but enforcement and penalties are dealt with at the member state level, or in the case of the UK, obviously now separately post-Brexit. So if we take the example of the UK, penalties can be up to £2,500 per infringement. So that could be per individual error that's been made. But in practice, customs will amalgamate this, and penalties in the UK don't tend to be on the high side compared to some other member states. Obviously, if you are found to have committed a violation and are issued with penalties, you have the right to appeal. And in the UK and the European member states, the way that would normally work is you have the ability to appeal for an administrative process first within customs, and then you can appeal to the first stage of the courts in that particular country if you're not happy with the outcome of that appeal. So next slide, please. So well before an audit, how can you prepare for this? We always say prevention is better than cure. So you need to make sure that you have proper records of your import operations. Quite often we see as a first step challenges in dealing with an audit because a company doesn't have records of their imports. So when customs say, I want to audit these 10 entries, they don't actually have those records. Records also enables you to carry out internal audits to make sure before customs comes around that you know what your weaknesses are, including how your broker is performing. And many errors can result out of broker underperformance rather than errors that you've committed yourselves. So monitoring broker activity is really important. Training of your staff so they know what to look out for in terms of the preparation for audit, but also the different pillars of customs compliance that we talked about previously. In certain areas, you may wish to think about applying for rulings and authorizations from customs. And one of the areas you can apply for rulings is tariff classification with binding tariff information in the EU and equivalent in the UK. You can also get EU-wide rulings for certain aspects of customs valuation. And some member states will also issue rulings for general valuation areas. And this is also an area where we expect an EU-wide system to be put in place in the near future. And the UK is also looking to put a formal process in place for customs valuation ruling as of early next year. You may want to think about AEO depending on the profile of your operations. As I mentioned previously, that will reduce your risk profile when it comes to audits. And finally, think about your compliance program. How are your risks managed? What kind of compliance personnel do you have? And that fits in with all of the other areas we've mentioned on this slide, such as record keeping, monitoring, broker activities, internal audits, etc. And we'll come in a minute about the trade cockpit and how you might be able to identify some of those areas of risk. So a few considerations from the UK perspective before I hand back over to Leo. So in the UK, you have a couple of specificities that are worth bearing in mind when it comes to this area. Firstly is the senior accounting officer. So if a company is incorporated in the UK and has a turnover of more than 200 million or a balance sheet total of more than 2 billion, either alone or if it's as a result of its aggregation of results with other UK companies in the same group, then it's required to appoint a senior accounting officer. And that will generally be a director or officer of the company who in the company's opinion has overall responsibility for the company's financial accounting arrangements. And that senior accounting officer has a personal duty to take reasonable steps to ensure that the company establishes and maintains appropriate tax accounting arrangements. And that includes customs to allow tax liabilities to be calculated accurately in all material respects. And that officer has to issue a certificate each financial year stating whether the company has appropriate tax accounting arrangements. So if there are concerns from a customs compliance perspective, the senior accounting officer would be responsible for highlighting those as part of that certificate, and failure to do so would result in personal liability for the senior accounting officer. And then the final point from a UK perspective is companies will be subject to regular business risk review meetings with UK Customs. And as a result of those meetings, UK Customs will determine the company or the group's tax risk rating. And it can range from low, moderate or high. And depending on that risk rating, there will be an increased level of scrutiny on all the returns submitted to the UK tax authorities. So errors of compliance from a customs perspective can negatively impact a business's risk rating and therefore potentially spill over into that company's other tax areas and how they are assessed from an overall tax risk perspective. And now moving on to hand over to Leo to talk about trade management and trade compliance risks. Thank you.
Thanks a lot, Jenny. I think that it's quite key what you just said. It's quite key for all the people attending to really carve that in stone in their head, because it's quite fundamental nowadays with all the wave of audit that we see, that to have a good a good view on how things are happening and what triggers actually an audit. One thing that for me is also quite important is to certainly also, get out of the thought that there is a compliance risk are just one size fits all, that it can only be one bucket of risk. We see it's much more than that. It's we cannot afford ourselves to have a tunnel vision on this. What we see on our everyday life is that it's very often a lot of different elements that gives rise to audits, but also to trade compliance risk. So of course you have the legislation, and you talked about that, you touched upon that, Jenny. But we see that for companies that are active in one country or multiple regions, multiple countries, the regulatory changes, keeping up with the regulatory changes, appears to be quite a challenge. You have the structure of the companies that are changing, that are not the same in the different regions. You have, for instance, also companies that acquire others and that they need to integrate. So there we are a bit between the customs legislation and the customs operations. Can I just take over that license without doing anything? Customs legislation, customs operation. How do I need to do that? So you have different areas like legislation that can give rise to compliance risk. You have operations, obviously, lack of knowledge of certain very local rules could give rise to that. The absence or just inappropriate, inadequate SOPs and procedures that have been put in place within companies. Also the public authorities. We very often think that it's only due to the changes of the legislation, the changes of your own operations, but the public authorities also, they undergo quite a change nowadays. New IT system, new methods, development of certain criminality. For instance, in Belgium, I'm based in Belgium for the moment, the customs authorities, they are really heavy looking at the drug traffic, because Belgium is now unfortunately one of the hub, the platform for entering drug into the EU. And so that's something that changes also the way public authorities are conducting their audit and their focus. So technically, yes, it brings more risk to your supply chains. So also risks are not only external, they can be also internal. Why? Because companies are quite important, quite large. They have different departments, different IT systems, and that's where compliance risk also can be spotted. And then finally, and it's quite an obvious one, the third parties. Of course, third parties are quite important. And when you think about how do you work with a broker, how a broker is working with his client, working with carriers, with all the different people within that chain, that supply chain, that deserve proper attention, that deserves a very good contract, an understanding of how we work together. If you don't do that, then that's I'm not going to say that it's a recipe for disaster, but very often it leads to issues. So if we progress also on the next slide, if we can go to the next slide, there we will see very highly how to mitigate the trade compliance risk. I know that Jenny has touched upon certain of these elements, so I'll be a bit quick. I'll be a bit quick on those in order to leave also a bit of time on the 2-3 last slides. So how to mitigate trade compliance risk? Of course, there is no, again, one size fits all, but I think that it's quite important. If you want to mitigate trade compliance risk, first you need to have a vision. You need to have a strategy. In other words, don't micromanage. Think about how is, on the macro side, how am I conducting my activities? If you only micromanage, that's where you will miss a bit the overall vision, and that's where the issues will come across. Assign roles and responsibilities. The who's doing what is very important. Not one person can do everything. That's also a recipe for disaster. Making sure that you prioritize where you want to be active, where your focus is, in order to maximize the efficiency, and certainly to have a strong process in place. You cannot get it right from the first time. So feel free also to be humble and to remediate and regularize when necessary. And then actually, it's not because it's good or we think that actually we haven't been audited that actually it makes it a good an efficient process. So technically good is not enough. And once you've done all of that, you go back to point one and you enlarge the scope and you repeat. So that's some recommendations on trade compliance risk based on our experience on the everyday life. Now, if we go looking at what the future holds, and I'll keep that relatively short in order to allow a bit of time for Q&A. Looking forward to the future, and I like that slide. Even though I never thought that it was rocket science, but it's I think that actually people need to keep that in mind, because that's really also on the basis of why people are going to trade compliance and investing in trade compliance. Very rapidly, we all feel that pressure to reduce costs, to keep costs under control. Going to trade compliance and thinking about how you could do the same thing in a better way and bring more benefits, that's really key to that. So technically there is a pressure to reduce cost. We said that regulatory complexity is not going to stop. It's going to push forward. So you need to be there. Getting a good trade compliance program or a vision or control methodology is something that is quite important. Lack of central visibility. Why? Because very often people are with 2, 3, 4 for a region to master a region that has all its complexity, is very specificities, all countries in there as well. So it's very difficult to keep up. So all these elements are really getting people to look for trade compliance solution that must be scalable, that must be flexible, that cannot be too expensive, but actually bring you some great visibility and control. And that's what a bit, as I very often say, humbly but firmly, also we are very conscious of that at Bakers, and that's where we have worked around the Baker trade compliance approach, and we have indeed developed. On the next slides, please. We have developed a trade cockpit that is based on almost 10 years of experience working with data mining, data scientists, working on really what matters for trade. And that's where we now are able to come in with companies with actually not only looking at commodity codes for one region, but across the board, going about identifying what are the issues with the commodity codes, what are the issue with the customs broker and the work that is being given and produced by the broker, or in the broker gets not correct data in, it will not be in a position to perform a good job. So we're looking at the commodity codes, we're looking at customs value, we're looking at origin and customs broker, and when we give back to clients is really a tool, a solution that enables them to, in one look, to see on the dashboard what is happening on a monthly basis, on a quarterly basis, on a yearly basis, so that actually you can take appropriate decision. And those decisions, they can be strategic, but they always have an impact on compliance, mitigating the risk, and going after the savings. So I think that actually in today's world, that's something. Having a view, having a control on your supply chain is quite key. And if you can summarize a bit of all that we've said now, we see an increased pattern for and focus on risk and pattern for trade risk emerging now. We see authorities getting ready to rumble. So it's our duty also to try to stand on the side of our clients, saying, guys, we are there, we can have your back, but actually it's going to be a work together. And one of the solution that helps quite a lot there is the trade cockpit. So Jenny, that was for me. We have a final slides indeed before we ramp up. Also, that summarizing what I just said, saying that actually it's not one size fits all. If we move to the next slide, on one size fits all, but it's really on it's an evolution. It's a journey. You cannot have the trade strategy with everything done right from day one. You go gradually there. You prioritize, you focus, and then actually you adapt. And for us, it's really all about that journey towards a trade strategy, and it's clearly very important. And maybe on that note, maybe Jenny, do you want to say a final word before maybe we take a few questions, having a look at the Q&A?
Thank you, Leo. Well, I'd just like to thank everyone for listening to our presentation. I think that what you just mentioned is that it's a journey for many companies, and one that we're seeing, sort of mirrored in a way with the approach that customs authorities are taking at the moment with this increased enforcement, and as we've seen the focus on the key customs pillars. And with that, Leo, there was one question for you, which is with regards to what you've seen in terms of the trends, particularly in Belgium, the types of trends that you've seen in customs enforcement. How are things being operated at the moment? What kind of approach are the authorities taking?
Yeah, that's quite it's a good question, because very honestly, we are quite in the middle of a change in Belgium. We see authorities, and maybe it's due to COVID, maybe it's due to the economic crisis, but we see authorities that are much more ready to get to somehow litigate, and also to go to court cases, rather to lawsuits, rather than to sit down with the companies and try to find a solution / a transaction. When a trade compliance breach has been observed by the authorities, or at least when they have questions, before it was quite rapid, and then we could sit down with the authorities, and then we will see who's right, who's wrong. But at least we had the opportunity to get into a transaction. Nowadays, authorities, the time is much longer, and they immediately go to actually the court case. So technically, that's something that it's a trend that it's a bit worrying, because it's for us, it stresses the fact that it's really important for them today to get directly to the solution, and directly to potentially the fines that they can impose. So I would really invite everybody that is working in Belgium, but not only in Belgium, to really go for and be very attentive to the trade compliance position, because that's something that is being challenged with the authorities, and that can be on valuation. The last cases that we had was a classification, so they getting back on classification, a bit less on origin, but certainly valuation is very high on the agenda.
Yeah, and we've seen that as well in other European jurisdiction as well. I'm thinking of our recent experience with Germany, where the German customs authorities treated a matter immediately as criminal, and then it's a matter of negotiation to get it back down to a civil matter. So certainly a trend in more aggressive enforcement across a number of different jurisdictions. There's one more question, Leo, and this may be one possibly more for our VAT colleagues, but question that we've received from the audience. It's a German corporation, and they purchase products from EU member state countries, ex-works, and then export them to Asia. In this case, the question's of that case, VAT question, should VAT be charged to us, the German corporations, by their EU suppliers?
Yeah, so there the question, it's a good question. The ex-works element is always an element of stress for the companies. So the question is, if I'm based in Germany and I'm buying goods in the EU, but it's ex-works, and once I've bought them, export them, will I be charged with VAT? I'm going to try not to answer by it depends, but of course it depends on how you structured your supply chain. But basically, it's possible to buy local EU national countries. So if one of your suppliers is based in Italy, and you do Italy, Germany, and it's a local sale, normally Italian VAT is applicable on your invoice. But if you can demonstrate that immediately the goods were exported, and then you can demonstrate that, and that you're in charge of the transportation, then you have the article of the VAT directive that can be applied, and that can help you in that respect to alongside with your supplier to agree that no, that invoice should not mention VAT because of the subsequent sale. There are always two operations here, and so it's very important to determine who is in charge of these transportation, because that will enable you to exempt, let's say, the VAT on that invoice. If you do not structure that in a correct way, then yes, that sale will be localized in Italy, because I took the example of Italy, and if you don't structure that correctly, then Italian VAT will be applicable. Of course, that's a VAT that you can recover, but nonetheless, you still need to pre-finance it. So technically, it's important. I think that in the question also, they mentioned Switzerland and Turkey. If the goods are coming from, if you source from outside of the EU and bring into the EU before re-exporting them outside to Asia, if that's your structure, then of course you import within Germany. Germany doesn't know an efficient doesn't have in his VAT legislation an efficient VAT deferment license like the Netherlands, like Belgium, like France nowadays. So it's a bit more pre-financed there on the importation from Switzerland before pre-financing the VAT. I mean, before re-exporting that to Asia. If the question was to say I'm exporting directly from Switzerland X works, then it's of course another question that potentially might trigger VAT registration in Switzerland, but not compulsory, because if you only perform a purchase in order to export, normally you can also get yourself an exemption of VAT registration. So you see, I've tried to give as many elements as possible. It a bit depends on what you're doing for the moment and the way you want to structure, but definitely yes, it's possible to get some VAT exemptions on the structure that you have explained. Well, I hope I've been sufficiently complete.
Thank you, Leo. And it's obviously an area then that you need to keep all the records, particularly the supplier, if they're audited by the tax authorities, will want to prove that the goods were exported, which can be tricky if it's ex works and they haven't handled the exportation. Otherwise, they could be subject to a VAT liability for the VAT, which they didn't charge for that particular export. And with that, I'm going to hand back over to Yoko. Thank you very much, everyone.
Thank you.
Thank you very much, Jenny and Leo. Please join me in thanking our speakers, Jenny and Leo, for an excellent presentation on the latest customs audit trends in EU and the UK. For more information, or if you want to discuss more, please do reach out to us. On behalf of Baker McKenzie and the IMT Group, thank you for joining today's webinar. We hope that you found this session informative and relevant for your company's operations. We would appreciate your feedback through a short survey, the link for which will appear on your screen after the session has ended. Goodbye for now and have a great rest of the day ahead. Thank you very much. Bye-bye.